I mean, obviously, the missed opportunity certainly as a result of the dynamic, the mental health issues mostly in high school as a result of the dynamic.
Okay, young man, look. If you're looking to use this case either to receive some type of compensation or something regarding how you perceive your parents may have treated you, or to somehow believe that this court has some power to rectify all of that in some way, that can't happen here. So you need, if you don't want me to sign this conditional order of dismissal, I won't sign it. But you need to tell me what you want me to do. I can make a finding right now on this case, or I can sign this conditional order of dismissal if that's what you want me to do. I'm leaving it to you. What do you want me to do?
Can I ask a follow-up? Is there any case on a basis of torts law, damage done to me by the parent-child dynamic?
Say that last part. Robert Groden versus David Groden.
Yeah, you have a consent order in front of you, drafted by Joshua Fink, executed by Mr. Groden. He asked me if he could address the court.
Yes, sir.
Hi, Your Honor. So I signed a conditional dismissal to vacate my parents' house by the end of January. I just wanted to write you a letter. I'd like to kind of make the case to you.
All right, you'll have to speak up, but go ahead.
I've had a difficult relationship with my parents for a long time. People can influence others to various degrees, especially within a parent-child dynamic. I once had a supportive dynamic with my mother before we moved, and she started to struggle with serious depression in and out of inpatient for most of my high school years. Once my mom was depressed, my dad took over. My dad is extremely dominant person. It could be quite aggressive. He set a dynamic up of intimidation and dominance, emotional violence, and extreme emotional abuse and control. I do believe that this sort of behavior precipitated my mother's serious depressive episode. I immediately started struggling with anxiety and depression and underperformed in school. Prior to that, I was an exceptional student. I believed he abused his position of power over me and took advantage of my vulnerability during that period and exerted a damaging degree of control over me that was emotionally abusive. I had a serious relationship during college that helped me realize the negative influence that this has had in my life path. I've been at the house after graduation to try to rebuild my life in a different direction. I've dealt with torment on a daily basis, threats of eviction without process, attempts to skirt the law in order to throw me out, including him assaulting me. Now, I understand there isn't much legal precedent for my side of these types of cases, but I can't see how I can get away with this. I'm trying to rebuild my life, staying at the house while I do so. I sought legal counsel, but I largely don't have a legal basis to fight this eviction. The two lawyers I found willing to represent me, I can't afford. I've asked my parents to consider mediation. They've dug in and accused my framework of being evidence of mental illness with no diagnosis. Obviously, it's difficult to ask people in power to recognize their faults. I've sought out different legal representation, but especially given the holidays, it's been slow to find an attorney. To be clear, I don't have a diagnosis besides a degree of anxiety, mostly from the situation. I've also proposed paying rent, which they've rejected. This is really nothing more than a power play consistent with our dynamic. My parents have agreed to a conditional dismissal if I leave by the end of January, but given the perspective outlined above, I really don't believe this is fair. I hope you may consider granting me an adjournment so I can continue to try to build a case and seek mediation and come to an agreement with my parents.
Let me just stop you there.
Yeah.
Do you not want me to enter this conditional order of dismissal? I mean, you signed it, correct?
I did, Your Honor. I understand the ramification of an eviction on my record, and it wasn't clear to me if I could be able to make a case today.
Say that again?
I wasn't sure if I'd be able to make a case today, and I understand the ramifications of eviction on my record.
Hold it. Yeah, man. You signed this today.
Yeah, yes, Your Honor.
Your Honor, he both signed it here today and he emailed a signed copy to our office before I showed up with that hard copy. And I'll also just point out to the court and Mr. Groden, and I don't care whether he makes a statement, but there is no triable issue. He was given a notice to quit. The time period has passed. He has no lease. He has no right to possession. And actually the notice to quit was just done as a precaution. So there's no triable issue. The alternative would be 10 days.
What do you want me to do?
I'd like a judgment to try to, I don't know if this is possible, I'd like to try to seek mediation.
Okay, but you don't have a lease at the premises, correct?
Just a month-by-month tenancy lease.
Okay. You're given notice to move.
Yes.
What would then happen is that's the alternatives. There are a few alternatives here. One, there could be a judgment entered. One, I could set it for trial if there's something for me to try even. Or the alternative is a conditional order dismissal. All right. If you want to hold a trial on it, then I have to make an assessment as to whether or not there's even anything that I could try, anything that I would have to make a finding on. Okay. So everything that you just said to me about your relationship with your parents and all of that, let's assume we went to trial and I found all of that to be true. And again, just assuming that to be the case, because I don't know. But if I listen to all the testimony and I make a finding that everything you're saying is true, I still would grant them a judgment on this issue of possession because it doesn't relate to your tenancy. It may relate to your family dynamic. I don't have any doubt about that, but it doesn't relate to the tenancy here. Now, just so that you fully understand, if I make that determination, because right now I see nothing that I could try, nothing that you could call witnesses on that's going to make a bit of difference as to the possession issue. So right now, as we are sitting here today, what you have is I would make the finding in accordance with law that there's no tribal issue. I'd issue a judgment. If I issued that judgment, number one, you'd have a judgment on your record. Number two, it would be 10 days. But because of the holiday, you get to the 16th. The conditional order dismissal, which it seems to me that you had notice of, send it back to them. It comes in here, you sign it again, gives you to the 31st.
Understood.
So you need, if you don't want me to sign this conditional order dismissal, I won't sign it. But you need to tell me what you want me to do. I can make a finding right now on this case. Or I can sign this conditional order dismissal if that's what you want me to do. I'm leaving it to you. What do you want me to do?
Can I ask a follow-up? Is there any case on a basis of torts law, damage done to me by the parent-child dynamic?
Say that last part.
Would there be any basis for a case through torts or personal injury case as it relates to this eviction? Eviction being damages for.
What personal injury?
I mean, obviously, the missed opportunity certainly as a result of the dynamic, the mental health issues mostly in high school as a result of the dynamic.
Okay, young man, look. If you're looking to use this case either to receive some type of compensation or something regarding how you perceive your parents may have treated you, or to somehow believe that this court has some power to rectify all of that in some way, that can't happen here.
We'll go with the conditional dismissal. That's okay.
Pardon?
I'll accept the conditional dismissal.
You understand that the terms of the conditional dismissal are that you would vacate the premises by January 31st.
Yes.
And that you would not, if you haven't vacated the premises by that date, that they could seek an order without notice. They could seek the entry of a judgment and an order of eviction to have you removed from the premises.
Yes.
You understand that? All right. And you also understand your rights to 3-day rescission that was explained to you and is contained in here. Is that correct?
Yes.
All right. Do you have any questions whatsoever regarding anything contained in this conditional order to dismiss?
No.
This file is conditionally dismissed. You can stop out at the front counter and pick up a copy. Thank you.
Thank you, Your Honor.
Doesn't apply to this circumstance.
I'm sorry?
The UCC doesn't apply to this circumstance.
It's a commercial transaction, Your Honor.
The UCC does not apply.
Okay. So where could I find this at that says that this isn't a commercial transaction?
That would be your assertion. I'm telling you it doesn't apply to this.
Just for my understanding that the Uniform Commercial Code governs all commercial transactions in commerce. And so based off of this law, tender of payment is why my defense is that once the tender of payment was refused, at that time, the charge or the total amount was discharged.
It does call the case of Group 5 Management versus Roderick Smith.
Good morning, Your Honor. Carrie Zanin, PC 7390 on behalf of plaintiff, standing in for Mr. Weiss.
Good afternoon.
How you doing, Your Honor?
What's your name, sir? What is the claim in this case?
Judge, this is a non-payment of rent action with a money judgment being requested as well. I'm showing that rent is due in the amount of $1,588, court costs of $217 for a total rent retained of $1,805.
And sir,
Yes.
how do you intend upon paying this?
So, Your Honor, I actually tendered payment to Group 5 Management on November 3rd. And my form of payment was refused.
Was what?
My form of payment, she refused payment.
What was your form of payment?
A cashier's check. I actually have the voided check here. And I'm asking for
You had a
yes.
cashier's check? Let me see.
If this is also the refusal in the email from the landlord. All right.
Danny, do you know anything about the refusal of payment?
I do not, Judge. Obviously, I'm standing in for Mr. Weiss. I believe my client or the client was supposed to be on. My understanding was that it wasn't a cashier's check. It was a counter or a check. And the reason it would have been refused was because he's had more than 3 checks come back as insufficient funds. But I would ask if my, I don't see if he's on here, Judge.
From Randolph Court or Group 5 on the Zoom? We don't have anybody checked in.
We don't.
Email.
Judge-
Hang on, Ms. Zane. He has an email saying about the refusal. Well, it's a text message screenshot.
Yeah, it's a email. I actually
Okay.
screenshotted it.
And it says from somebody with the last name of Aslam, ASLAM, indicating that they received the rent check in the sum of $1238, which the check that he showed me was in the form of an over-the-counter check. However, must be certified funds. And then, second page, as the system will not accept this, maybe. But
Yeah, Judge, my notes on the ledger show counter check, which is a check that's not, it's one of the ones they give you from the bank. And so again, that's
Okay.
the position I was taking anyways, it was refused.
so,
because-
sir,
Yes.
is there a reason why you can't get certified funds to the landlord?
Well, they actually accepted December's rent from the same check, Your Honor, from my bank.
Okay, but if
Well, because it costs. And my defense is that under Uniform Commercial Code 440.2511, by tender of payment, 2 and 3,
it's not applicable to this case,
and could you tell me why, Your Honor?
because the UCC doesn't apply to this circumstance.
I'm sorry?
The UCC doesn't apply to this circumstance.
It's a commercial transaction, Your Honor.
The UCC does not apply.
Okay. So where could I find this at that says that this isn't a commercial transaction?
That would be your assertion. I'm telling you it doesn't apply to this.
Just for my understanding that the Uniform Commercial Code governs all commercial transactions in commerce. And so based off of this law, tender of payment is why my defense is that once the tender of payment was refused, at that time, the charge or the total amount was discharged.
Even if you were to do that analysis, you can't then have unjust enrichment, which means that you want to move.
I'm sorry.
You can't have unjust enrichment, so you'd have to move because you can't have the apartment and not pay.
No, I mean, I paid the rent. They took the exact form of payment in December.
Sir, are you going to tender a check or no? Or certified funds to them?
I'll tender payment.
Are you going to tender certified funds for the 1805?
So, Your Honor, my rent is $1238, and just the extra $700, $600. I'm not sure where it's coming from, but if they accepted the rent payment and from my bank in December, I'm sure I don't know why they wouldn't accept it now. They refused November, and then
Okay.
they accepted December.
Sir,
Yes.
I'm asking a very simple question.
Yeah.
Are you going to tender certified funds to them in the amount of 1805?
I will surrender. I will submit funds.
Certified funds to them.
I plan to. It costs me to do certified, so I would.
As does
I would
the
like to.
NSF transactions that they've had in the past. So that is my question to you. Are you going to submit certified funds
I'll submit certified funds.
in the amount of 1805?
I like to debate that amount because I'm not sure where that amount's coming from. My rent is $1238. In court costs, I'm not sure where the other $600.
All right, here's what I'm going to do.
Yeah.
Defendant to submit $1,238, which at this point is the undisputed amount in certified funds to the landlord no later than December 29, 2023. And then we will look at the disputed amounts. I will adjourn this matter to January 5th, 2024 at 2 p.m. And I would just note to you, Mr. Smith, that if those funds aren't in, I'm not hearing any additional argument. I will be granting a judgment, which will be for the full amount, plus what will at that point be January's rent.
Your Honor, also, the 4th I have to work, so every time that I'm coming here, I'm having to take off of work. And
Sir, I cannot help that.
I mean, is there a way that we can set a different date?
That is my next day.
Okay.
Thank you.